right, well, first, can you hear us okay? All right, great. Good morning, everybody. I'm Attorney General Josh Kaul, and I want to thank you for joining us here today. We're here with a significant announcement about a resolution in a housing case in southeast Wisconsin. Before I touch on that, I just want to say briefly that the victims and everybody who is impacted by the school shooting at Abundant Life in Madison the other day remain in our thoughts. Our office, through our Office of School Safety, has been involved in supporting efforts at the school. Our office assisted with reunification efforts with the students and working to reestablish psychological safety and to support teachers and staff and students as the community works to heal is going to be critical going forward. So again, my thoughts are with the victims and all of those who were impacted by that. Today we are here to announce that the Wisconsin Department of Justice has negotiated an agreement with Milwaukee landlord Yusef or Joe Berrada and his property management company, Berrada Properties Management, Inc., to resolve the landlord-tenant enforcement action that was filed on November 15th of 2021. The agreement this morning was sent to the Wisconsin Legislature's Joint Finance Committee for approval, and once that approval happens, the proposed agreement will go to the judge in the case for the judge's potential approval. This is a landmark agreement for housing in the Milwaukee area and for Berrada Properties tenants in particular. The agreement requires a monetary payment of over $1.7 million, as well as significant injunctive relief to address the harms that are stemming from the conduct that the state alleged violated Wisconsin law. Included in that monetary payment is a civil forfeiture of $986,000, slightly more than that, $986,455.92 specifically. Attorney fees and costs of nearly $250,000, as well as other surcharges and fees provided by state statute, again totaling over $1.7 million. We are not aware of any other judgment of this size in a housing case in Wisconsin history. As part of the agreement, the defendants have agreed to vacate and seal eviction judgments affected by late rent fees or attorney fees that the state alleged were illegally charged to tenants. And in addition, the defendants have agreed to implement several important programs to remediate harm. First, the defendants have agreed to run an income-based rental program for up to 300 of their tenants for a period of 3 to 5 years. Second, the defendants have agreed to participate in an eviction diversion program. Third, Berrada Properties Management has agreed to establish a $1.3 million credit account to make rent assistance grants to defendants' qualifying tenants. Fourth, Berrada Properties Management has agreed to offer up to $400,000 in move-out assistance payments to defendants' tenants facing eviction to help the tenant move before an eviction is filed. These remediation programs, income-based rent, eviction diversion, rent assistance, and move-out assistance, will be overseen by a third-party administrator, Community Advocates of Milwaukee, who you'll be hearing from today. The agreement also includes a restitution program that requires Berrada Properties Management to make payments to tenants who paid late rent or attorney fees that were not authorized, who didn't get full credit for their security deposit, had property confiscated, or were subjected to self-help eviction. Tenants will not receive a payment if the balance of the restitution owed is less than the balance of legally valid unpaid rent owed prior to the court signing the consent judgment. The defendants have estimated that approximately $850,000 in restitution will be paid under this program. And based on the state's allegations, Berrada Property Management previously returned to tenants over $1 million in late rent payments. Berrada controls more than 200 limited liability companies that combined own nearly 9,000 apartment units in Milwaukee and Racine. And Joe Berrada is the sole owner of Berrada Properties Management, Inc., which manages all of the apartment units. I specifically want to thank the DOJ attorneys and support staff, as well as the tenant advocacy groups who worked for years to come to this resolution. I also want to thank our partners at Community Advocates for agreeing to administer the remediation programs and for hosting us today. I'm joined today by several folks who are going to speak about these issues we're discussing. You'll hear from Maudwella Kirkendall, who's the Chief Operating Officer at Community Advocates, Deb Hefner, the Strategic Partnership Director at the Milwaukee Rental Housing Resource Center, and then you'll hear from Rachel Fox Armstrong. Let me just say that at the Wisconsin Department of Justice, we are committed to protecting the rights of all Wisconsinites. We work to ensure that our laws are upheld and that those laws are enforced when they are violated. When folks are facing housing instability, and in particular when they're facing the possibility of eviction, they are at a vulnerable point in their lives. And making sure that the laws that are in place for housing and other laws that provide rights for tenants are enforced is a critical part of the work that we all must do to make sure that people are supported when they are at a vulnerable point in their lives. We are proud of this resolution, and we hope that it brings meaningful change and progress for Berrada Property customers and tenants. So with that, let me turn it over to Maudwella Kirkendall.
Thank you. Good morning, everyone. As you mentioned, my name is Maudwella Kirkendall. I am the Chief Operating Officer here at Community Advocates. On behalf of our Board of Directors, our CEO, Andy Elliott, and Shawana Lindenberg, our Housing Manager, we'd like to welcome you to Community Advocates. We'd also like to extend our gratitude to Attorney General Kaul, Assistant Attorney General Brissett, and the entire Wisconsin Department of Justice team for including Community Advocates and other housing advocates in Milwaukee as thought partners in the process to pursue a resolution to this case and for facilitating today's meeting. Since 1976, Community Advocates has provided advocacy and services to individuals and families so that they may meet their basic needs and live in dignity. Each year, we serve over 50,000 households through various 40 different programs and through our 4 different divisions, which include our Basic Needs Division, our Milwaukee Women's Center Division, our Public Policy Institute, and our Behavioral Health Division. Those programs center around several things, which include eviction and homeless prevention services, energy assistance, employment support, protected pay services, disability services, as well as mental health awareness and workshops. In Milwaukee, more than 50% of the households are renters. And of those households, when there are evictions, 90% of those evictions are a result of non-payment of rent. Oftentimes, this disproportionately affects low-income families, primarily women of color with children. These families often lack financial resources and safety nets to weather short-term hardships, such as car repairs, medical emergencies, or job interruptions. This is a reality that we work to address every day in our work, specifically with our SEMER Homeless Prevention and Case Management Program. SEMER focuses on long-term housing and economic stability by prioritizing the well-being of parents and the academic success of the children throughout the households. We utilize a holistic approach and also utilize a multi-generational approach to servicing those families. The SEMER model includes individualized case management, goal setting, budgeting assistance, and housing supports. In 2023, the SEMER program served over 300 families, and of those families served, 96% of those families maintained their housing stability. The resolution builds on our existing services and reflects Community Advocates' missions and values. It prioritizes housing stability, tenant support, effective communication between tenants and landlords, and alternatives to eviction. We are eager to administer the eviction diversion best practices outlined in this resolution and to pilot the income-based rental program in collaboration with our partners, including the Milwaukee Rental Housing Resource Center. And with that, I'll pass over to Deb.
Thank you, Maudwella. Good morning. I'm Deb Hefner, representing the Milwaukee Rental Housing Resource Center today. Milwaukee's rental housing resource landscape came under critical examination in 2018 with the release of Evicted by Matt Desmond. This powerful book drew national attention to Milwaukee's alarming eviction rates and highlighted the significant challenges faced by both tenants and landlords. In response, a coalition of housing advocates, government leaders, community stakeholders united to form the Milwaukee Eviction Task Force, which was convened by the Urban Economic Development Association. And today we have the Executive Director, Christy Lusar, who provided leadership to this effort. The group focused on addressing the root causes of housing instability through actionable solutions. They created 3 recommendations, which include resources for short-term rent assistance, providing a safety net for working families during temporary financial hardships, tenant-landlord mediation services, offering no-cost proactive approach to resolve conflicts as an alternative to eviction, and the development of a one-stop resource center, creating a centralized hub where both landlords and tenants can access tools, resources, and support. In 2020, these recommendations came to light with the launching of the Rental Housing Resource Center during the height of the pandemic. The RHRC opened as both a physical and virtual space, offering comprehensive support to thousands of individuals and families during a time of unprecedented need. Community Advocates is proud to serve as the host site for the Rental Housing Resource Center and work alongside our incredible partners, including Mediate Wisconsin, Milwaukee Justice Center Eviction Diversion Initiative, Legal Action of Wisconsin, Legal Aid Society of Milwaukee, City of Milwaukee Department of Neighborhood Services, Milwaukee County Department of Health and Human Services Housing Division, and the Rental Property Association of Wisconsin, the largest trade association of property owners in our state. Since its inception, the Rental Housing Resource Center triage team has served over 8,000 individuals thanks to their work and also our partnerships. I'd like to take a moment to recognize Erica Crawley, our Rental Housing Resource Center Director, and her team of outstanding triage specialists that are doing the work day in and day out. 4 years since its launch, the RHRC continues to adapt to meet Milwaukee's most evolving needs. The effort has evolved into what we now call the Milwaukee Opportunity, an integrated eviction diversion model that focuses on early intervention, resource triage, and tailored solutions. The solutions emerging from this resolution, announced by DOJ today, build on the pillars of the RHRC and represent hope for the future. By working together, taking the time to assess needs, and determining eligibility for resources, we can create pathways to the best possible outcomes, including long-term stability for individuals and families. We can also serve as a best practice model for other tenants and landlords. Thank you. And Rachel.
Good morning. I'm Rachel Fox Armstrong. I'm with Legal Action of Wisconsin, a statewide nonprofit civil legal aid law firm serving about 10,000 clients each year. At Legal Action, our mission is to deliver exceptional legal services and structural change advocacy free of cost to those most in need. We work with the organizations here and many others to help renters find and maintain safe and affordable housing. In Milwaukee, we represent clients facing housing conditions issues, illegal lockouts and self-help evictions, and eviction filings. We also provide legal assistance to low-income people who need help removing barriers to employment, addressing consumer finance issues, and navigating public benefits, all areas of law that help stabilize individuals and families and can in turn help those same people maintain their housing. On Mondays, Wednesdays, and Fridays, we operate the Eviction Defense Project, a court-based pro bono project offering same-day representation to tenants facing eviction. Throughout the past 2 years, we have assisted 406 tenants in their legal disputes with Berrada Properties. Our housing work, especially our Eviction Defense Project, is the first line of defense for tenants contesting evictions. We see firsthand every day the devastating impact evictions can have on individuals and families alike, and we know that there are solutions to reducing evictions that can benefit landlords, tenants, and the entire Milwaukee community. When the Department of Justice filed this suit in 2021, we slowly started to see a change in Berrada's business practices for the better. Berrada cases used to make up the majority of our clients, and now we see them in court considerably less often. The diversion program in this settlement has the potential to be life-changing for Berrada tenants. Many people don't realize that eviction filings can remain on a tenant's record from anywhere from 2 to 20 years. These eviction records then negatively impact a tenant's abilities to secure affordable and quality housing for years or even decades after the eviction itself. The diversion program can help Berrada tenants avoid unnecessary evictions and give them an opportunity to get back on track before facing an eviction filing. Sometimes all tenants need is a chance and some time to work together. Legal Action of Wisconsin is grateful to the Department of Justice for filing this lawsuit. We have already seen change, and we look forward to seeing more thanks to their work. Back over to you.
Great. Thank you. I'll open up for questions in a moment. The one thing I do want to make sure to emphasize is that the next step in the process is for the Joint Finance Committee to review and approve this settlement. They have that authority pursuant to legislation passed in late 2018, and so the resolution will need to be approved by the Joint Finance Committee, and then if it is, it will go to the court, which then we will ask the court to enter a consent judgment formalizing this agreement. So with that, we're happy to open it up to any questions.
Hi, Attorney General Irina Sandlin with WISN 12. Explain what started this case. What happened back in 2021 to lead to this landmark judgment?
There were a number of reports and other information provided relating to potentially concerning practices that we ultimately alleged in our complaint in this case violated landlord-tenant laws in Wisconsin. And if you take a look at the complaint we filed in 2021, we're happy to get you a copy of that. You can see the allegations that were laid out. We often work in partnership with DATCAP, and that's reflected here. But it's also important that folks who work in the community and see issues arise provide that information. And I know that some of the advocates you're seeing here and those they work with, I think did a really commendable job of raising awareness of some of the concerns that were going on. And it's, at the Department of Justice, we work to take on the cases we believe are the most significant and that can have the biggest positive impact on Wisconsinites. And so this is certainly a significant case, and as the complaint reflects, there were a number of alleged violations. And now the result today is, again, a forfeiture that we are not aware of any case that has had a larger forfeiture in a housing case in Wisconsin, as well as significant changes, some of which you've heard have already begun to be implemented, and others of which we hope will continue to make a positive impact in the future.
Do you envision this changing the lives of Berrada tenants for years to come?
We think there's going to be a significant positive impact for Berrada tenants, and that's the purpose of the agreement, is to try to both address the allegations that we raised, but also to ensure that we're doing more to support folks who are facing potential violations of the housing laws. We want to make sure that those laws are being upheld, in part because they're there for very good reasons. We have housing laws in place to protect people who are renting, and in particular when folks are facing eviction, which can have a lot of negative consequences, ensuring that those rights are upheld is critical. And I'm proud that we've done that here. And we want to make sure that those laws are upheld no matter who is renting to folks, so that every Wisconsinite who's renting is able to have their rights vindicated.
Can you explain the 1.7 monetary payout? Is that for all of the tenants who were involved in the original case?
The 1.7 is a forfeiture. Those dollars go to the state. It's composed of a few different things. There's the civil forfeiture of the $986,000 plus. There are the attorney's fees and costs, and then there are various other surcharges and fees that are set forth in state statute. That amount is in addition to the other amounts that are described here. So, for example, there's going to be the restitution that will be paid under the restitution program. Those will go to tenants who paid late rent or attorney fees that were not authorized, or who didn't get credit for their security deposits, had property confiscated, or were subjected to self-help evictions. Berrada has already returned over $1 million in late rent payments to tenants of theirs. And then there are the programs that we talked about as well.
A Dane County judge recently overruled Act 10, and Assembly Speaker Robin Voss has said that he is going to appeal that. What are your thoughts on
Yeah, so I'll come back to that question if that's okay. I'm happy to take off-topic questions, but while we've got these folks up here, I'll do the on-topics first.
I think that the extra step of having the Joint Finance Committee approve this lawsuit before it goes to court delays relief for the tenants of Berrada Properties.
Well, it certainly could. I mean, my hope is that the Joint Finance Committee will meet quickly and that they will approve this so that it can get to the court as quickly as possible. But that step in this process, which now has been in place for about 6 years, in my view, has added nothing to the quality of the resolutions that we're getting, and has just created an unnecessary impediment. That issue is in litigation right now, and so we're hopeful we will succeed. But in the meantime, we're working under the provision that is in place, and we hope the Finance Committee will move quickly.
Josh, are there any other large landlords that you guys are looking into at this point, or anybody else whose violations or potential violations would come anywhere near where Berrada was?
Well, so we don't generally speak to ongoing matters.
Without naming.
Yeah, what I can say is generally, we are committed to making sure that where there are significant violations of the law, whether it's in the housing context or other contexts, and those are having an impact on Wisconsinites, that we are ready to step in. And so to the extent that people are aware of violations, whether of landlord-tenant laws or other laws, I encourage folks to report that information to DATCAP. We then usually work with DATCAP, but also partners like the ones you see here. And I do hope that this resolution sends a clear message to those who don't follow the laws that are in place, that these are issues that we at the Department of Justice take seriously, that DATCAP takes seriously, and that we're committed to protecting people's rights.
Is the state going to continue to monitor Berrada Properties to ensure that he's complying with these changes stipulated in the settlement?
So there will be an ongoing process relating to this resolution. If the Joint Finance Committee approves it, it will go to the court, and we will seek what's called a consent judgment. It's a court order that orders that certain provisions be adopted in this case. That would be essentially formalizing the settlement agreement we've talked about. Once that happens, then Joe Berrada and Berrada Properties will have obligations pursuant to a court order. We have confidence that he will live up to those obligations. And there's going to be a third-party administrator, as we've talked about, at Community Advocates. So it's our hope that everything goes smoothly. If it doesn't, we will have a court order that can be enforced, and certainly we want to work with everybody involved to make sure that these programs are successful. As you heard somebody talk about before, having these kinds of programs, our hope is, will ultimately benefit the renters, but also everybody involved in the process, including the landlords, because by reducing evictions and promoting housing stability, we're having a positive impact across the board. So we are prepared to enforce the provisions if we get to that point, but it's our hope and our expectation that the provisions will be complied with.
One other thing is it's a mutual agreement. You didn't get a court order, this is a settlement. Is there a reason there's nobody from Berrada or Joe himself up there with you?
Well, we're just here today announcing the resolution. We don't typically do that with the folks who are on the other sides of our cases, but I will emphasize that the process is not completed yet, so it needs to go to the Joint Finance Committee. Once it goes there, it then goes to the court. So while we hope this resolves it, it's not yet a resolved case. We invited the folks who we worked with, the group here. The Berrada legal team has been in touch with our legal team on the resolution, but no, we're here with the advocates today.
I have one more question for you. Since you filed this case, Berrada Properties has continued to expand its stake in the city of Milwaukee's housing market. The assessed value of all of his properties in the city alone, near $500 million. Did you learn any more about the nature of his business and how he's managed to grow so fast?
So in the course of this case, we engaged in the discovery process. Our comments about the facts of this matter are limited to what we filed in court and what we've submitted to the Joint Finance Committee. So the allegations that that we've made in this case are the ones that were in the complaint that was filed previously in the case. And our focus now is on the resolution and making sure that we're able to have the impact that this resolution provides for.
You anticipate this is going to make life better for the tenants at Berrada's?
Yes, is the short answer. This is really a landmark resolution, and the advocates, I think, can speak more directly to some of these issues. But first of all, as you've heard, there have been some changes that have already been made. And secondly, the kinds of programs we're talking about can address the most significant harms that were alleged from the complaint, the violations that resulted in evictions, which can be life-changing events for folks. And look, it's Wisconsin. You can look outside right now, and the consequences of an eviction are obvious, but they're also extensive and can impact people throughout their lives, as you've heard talked about here today. I do want to invite folks up here if you want to talk a bit about the impact you anticipate from the settlement. If anybody wants to speak to that.
As I said earlier in my remarks, our best practice approach through community advocates work and also the rental housing resources is really to have the opportunity to assess the situation or the conflict and be able to offer resources accordingly. So, like moving from point 1 to 10, just by going to file the eviction, there's a lot of steps and a lot of processing and triaging that needs to take place to get to that point. So by having a team in place that can really assess the situation, whether it's they're late on their rent or some other tenancy issue, we have the ability to take a look at the big picture, and we have time to be able to assess for resources and provide those resources in advance of the eviction filing, which is so clearly detrimental on a record.
Just briefly, Carrie, I also wanted to add, you asked before about who's here or not. I just wanted to add, this is a resolution of a disputed civil case, obviously, and it is our hope that there will be partnership going forward. And in fact, that's a critical part of making some of these processes successful. We are going to have a court order in place, and so that also provides an obligation on those involved to comply with the terms. But at the same time, this is the resolution of a litigation, right? And so we are going to make sure that the terms are complied with and that they're upheld. And like I said, I'm confident that they will be, and we'll have a court order to help ensure that. But it is an ongoing process, and making sure that it's effective is critical so that the people who've been impacted by the alleged conduct are able to get the support that they deserve.
You mentioned that some of the terms of the litigation were even implemented by Berrada. Can you expand on that? I would call them, but they already did, and they said they wouldn't.
The question is which parts of the...
Yeah, you just mentioned a couple times that some of the parts of the agreement have already been implemented. You mentioned the terms of the payments. I was just wondering what's already in play.
Yeah, so let me sort of try to go through what's been happening and then where we're headed. So first, and if you look at our press release, some of this is detailed, but there's a lot in there, I realize. So Berrada Properties Management previously returned over $1 million in late rent payments to tenants. They have also estimated that pursuant to the restitution program provided here that about $850,000 will be paid. And that restitution program requires them to make payments to tenants who paid late rent or attorney fees that were not authorized, who didn't get full credit for their security deposit, who had property confiscated, or who were subjected to a self-help eviction. But tenants will not receive payment if the balance of the restitution that's owed to them is less than the balance of legally valid unpaid rent owed prior to the court-signed consent judgment. Then there are also the programs I mentioned. So first there's the income-based rental program for up to 300 of the Berrada property tenants. That'll go on for a period of 3 to 5 years. There's the eviction diversion program. There's the establishment of a $1.3 million credit account, which will make rent assistance payments to defendants qualifying tenants. And then there's the offer of up to $400,000 that will be provided for move-out assistance payments to defendants' tenants that are facing evictions to help the tenant move before an eviction is filed. And so, like I mentioned before, community advocates will be the third-party administrator so that there is an independent group in place to review this and to make sure that that the terms of the agreement are being complied with. And then in addition to that, there are a variety of injunctive provisions or provisions that require Berrada not to take certain actions. They've agreed to vacate and seal the eviction judgments affected by late rent or attorney fees that we alleged were illegally charged to tenants. And then there's the payment of the over $1.7 million, the monetary payment that we talked about before. So in many of those things, the Berrada property and Joe Berrada will be involved directly. But we will ultimately have the court judgment and the third-party administrator in place. Great. Oh, go ahead.
Is it okay if I ask you?
Yeah, why don't we switch to off-topic if you folks, thank you.
Thank you all, thank you. Attorney General Kaul, you started this morning by offering, your thoughts with the victims in Madison, a horrible, horrible week for our state. I kind of want to ask you about a lot of rumors swirling online right now. There are some reports that the father of the suspect purchased the guns. Is this something you're investigating? Could there be possible charges for the parents?
So the Madison Police Department is the lead investigative agency on this issue, so that's the agency that can speak to what's happening with the investigation. I will say it's obviously an ongoing investigation, and I know that the police department has provided information where it could and initially provided a lot of information to the public. But I know that that's an ongoing investigation, and their office can speak to any details that they can provide and potentially where it's headed.
I mean, are charges for the parents something that could happen?
Well, in any case, you want to investigate the facts fully and figure out precisely what happened. I'm confident that's what the Madison police are doing here. I believe the police chief made a statement related to this yesterday, but I think they're going to gather the facts as fully as possible and then sit down and assess what to do with them. With respect to anybody who may have had any involvement, they will make their decisions, I'm confident, based on the facts they gather and then working with the DA's office on any charging options.
DOJ in charge of the Office of School Safety, I mean, where is that investigation? Are you looking into what could have been done to prevent that girl from coming into school with a gun?
So the Office of School Safety has been engaged in the response to this tragedy. The day of, the Office of School Safety responded. They have critical incident response teams that they've trained around the state, and members of the critical incident response team in that region responded and provided support, including assisting with the reunification process between parents and students. And then the Office of School Safety continues to provide support to the staff and the students, the staff in particular right now, to help support the process of healing and addressing trauma and ultimately reestablishing safety, psychological safety at the school so that students are able to return and feel comfortable. That's not an investigative agency. They provide support to schools in their prevention efforts and in their efforts to respond to crises. But to the extent that there is information gathered, and there certainly will be, there always is when these kind of horrific incidents happen, we certainly want to take a look at that and figure out how that can factor into the guidance that our Office of School Safety provides to schools. The other thing that's important to note is that we know from a lot of research and sadly from a lot of incidents involving mass violence that cases involving targeted violence are ones in most cases in which somebody goes down a pathway to violence. It's rare that it's a situation where somebody all of a sudden wakes up one day and decides to commit violence. Instead, there's a series of things that may lead to it. There are various signs that can indicate that somebody may be on that pathway, and there are interventions that can help prevent targeted violence. That's one of the things that our Office of School Safety trains on, and there's actually an e-learning module online folks can look at that provides information about signs of targeted violence.
Will the Office of School Safety make any recommendations on physical barriers to make the school safer moving forward?
Our Office of School Safety is on an ongoing basis working to assess what improvements we can make in best practice guidance for schools, but also for policies that are in place. One of the things that office did was administer significant grant funds that were provided by the legislature for physical security upgrades at schools. And one of the things that we try to keep an eye on around the state is whether there is additional funding needed, both for physical security upgrades, but also for other types of programs. One of the most effective programs we know, a data-driven program, is our 24/7 tip line. It's called Speak Up, Speak Out. Anybody who has a concern about a school safety issue can report that concern. But ultimately, what we know is that preventing acts of targeted violence, it requires a multifaceted approach. There's not one simple solution that will prevent every incident from happening, but there are a lot of things that we can be doing to help make it less likely that any incidents happen. And so when any tragedy like this happens, making sure you look to see what you can learn from it is critical, and that will be part of what we and others will do. But ultimately, making sure that we've got physically secure school environments and that there's an opportunity for students and staff to report any concerning issues as they arise is important.
Going back to Act 10, a Dane County judge recently overruled Act 10, and Assembly Speaker Robin Voss said he would appeal that ruling. What are your thoughts on that?
Well, first, that case will obviously continue to go through the court system. We have been involved in that litigation, and we are in the process of assessing the next steps in that case. But this is obviously a hugely significant issue for the state of Wisconsin. It's one that has been the subject of significant public debate, and so I think it will continue working its way through the appeals process, and there's certainly a high likelihood that it ends up being decided by the state Supreme Court. But I think having the issues fully litigated and ultimately resolved through the legal system that's how our system should work. So I'm certainly not surprised that the legislature is appealing. And ultimately, I think the case will be decided for the long term by the state Supreme Court.
All right, one more thing about the Joint Finance Committee. The appeals court today decided that overruled the previous appeals decision in part. Just wondering what your next steps on that are now that your cross appeal has sort of not been entirely completely successful.
Yeah, so that was a 2-to-1 divided decision that was just released this morning. And there was another decision relating to the Joint Finance Committee from that Court of Appeals recently. We will be seeking Supreme Court review of that case. The papers will be filed in the days ahead. We believe that we are on the right side of the law in these cases. We were not entirely, but largely successful before the circuit court. And each of the Court of Appeals decisions were 2-1 decisions. So we look forward to continuing the litigation process and hopefully finally getting full resolution of these issues. These statutes were passed in late 2018, and we're now in late 2024. So we look forward to getting resolution. Though I do think it's important to always note that these are really senseless laws that were passed by the legislature. I talked about that 6 years ago. But you can look at what impact they've had, and it's hard to point to any positive that has come from these laws being in place for 6 years. I'm not sure that the legislature has examples they would point to. So it's my hope that these are finally addressed and, where appropriate, ruled unconstitutional, or that the statutes are interpreted clearly so that there's no uncertainty about what the law provides.
Thanks.
All right, well, thank you all for being here. Appreciate it.